We welcome all officials of the department who are with us today and our guests. You are warmly welcomed. Thank you, Advocate. You can carry on.
Sure thing, Chair. We are looking at the amendment or the substitution of Section 99 from the Principal Act. Section 99 deals with limitation of liability. So this is what it looked like. Just to show that one there to members, the new proposed Section 99 has the following change. It will read, no person, including the state, is liable in respect of anything done or omitted in good faith in the exercise of a power or the performance of a duty in terms of or by virtue of this act, or in respect of anything that may result therefrom. So, Chair, the change is the Act had reference to employee of the Civil Aviation Authority. So the new proposal is more all-encompassing. So it does include those employees by reference to including the state. Chair, then if members are okay with that substitution, we will be able to move on to the next clause.
If members are okay, let me see the okay from members or any other issue.
Chairperson, if I may.
Yes, Honorable McDonald.
Chairperson, I've got no problem. I continue with that. That submission is fine, Chairperson. We can continue.
Thank you very much. Any seconder? Anybody who seconds? Okay. Anybody who has a problem or any issue to raise? Boramadwa?
Thank you, Chairperson. I second Honorable McDonald.
Thank you, Boramadwa, Honorable Miriam Ramadwa. Can we move, Advocate?
Yes, Chair. Our next clause, clause 25, is proposing the deletion of the following subparagraphs in section 103, M, N, and O. So just to show members what they are proposing we remove, it's in section 103, National Civil Aviation Security Responsibilities of Department. They are proposing that we delete these three subclauses. So the bill seeks to then remove M, the development of effective strategies to secure compliance with aviation security standards. N, the assessment of security-related decisions taken by industry at all levels for the impact on aviation security. And O, the conducting of regular and timely assessment of international security developments. So, Chair, as well as this amendment, if members agree to the amendment of M, N, and O, the drafters will also just have to include here an insertion of and after design here in K, so that there is a full stop, so that it just reads, but I'm sure they will pick up on that. So, Chairperson, the proposal is the removal of M, N, and O in 103. So I'm just going to leave these three on the screen for members to consider, Chair.
Thank you very much, Boramadwa. McD.
Chairperson, good morning, colleagues. Again, Chairperson, Chairperson, I'm a bit worried, Chairperson. I don't think that we need to remove those three items, Chairperson. Specifically, in the conducting of a regular and timely assessment of international security developments. Chairperson, we are a signatory to the ICAO in South Africa, and we also have a lot of potential threats to South African citizens regarding aviation that rely heavily on international standards, especially related to terrorism and those type of things. As an example, Chairperson, one of the regulations that happened after the 9/11 tragedy in the United States was that there was a stipulation on the security on airports and the amount of liquids being able to carry on an airplane, the scissors, etc., and also the strengthening of cockpit doors to stop intruders to get into a cockpit. There was also, if you look at the German wings plane that flew into the mountain, where the pilot committed suicide, has now brought other parts in the ICAO which will allow, under certain a PIN code for somebody to get into the cockpit. Chairperson, we need to comply to international standards. We can't be a signatory to something and then want to dilute our bill. Chairperson, items there, Chairperson. Thank you.
Thank you, McD. Advocate. You want to say something on that one?
Chair, I think the department can just clarify why they are proposing the deletion and maybe address whether it's covered either under SACA's Act or whether it's covered or will be covered under the regulations. Chair, I think they can just provide some clarity there.
Before they provide clarity, let me get Honorable May.
Sorry, sir, it was a fault. Thank you.
Thank you, Mr. Zukudo.
Thanks, Chairperson. Sukudo is responsible for the step bill. Masombo and Livers will be continuing with yourself in this regard. Can I proceed?
Yes, Date Masombo, proceed.
Thanks, Chairperson. Clause 25 amends Section 103 of the Act to remove the provision conferring certain powers relating to aviation security which have already been bestowed to the Civil Aviation Authority by virtue of Section 73 of the Act. So those powers are already covered under Section 73 of the very same Civil Aviation Authority Act. The segregation of powers relating to aviation security was highlighted during International Civil Aviation Organization security audit conducted to verify the aviation security functions of the Republic. So those sections, Chairperson, are already covered under Section 73 of the same Act. Thank you.
McD, are you covered?
Chairperson, I didn't hear everything. My connection dropped down, Chairperson. I don't know, Chairperson. I'm taking this under advisement, Chairperson. I'm not 100%. Chairperson, why do we specifically have to remove it from that part? Is more not better than less, Chairperson? I don't know. Chairperson, I'm not convinced, but I will wait for guidance, Chair.
No, they are saying they are covered under section what, advocate?
Under Section 73 of the same Act, Chairperson.
Do you get that, McD? Okay. If they are
okay,
covered,
Chairperson.
thank you very much. Let's get Honorable Manu.
Good morning, Chair, again. I was going to request what Advocate Nell has just done. so that we can read the section that is said is covering it. Maybe that's where Honorable MacDonald can satisfy himself, because the response is that it's already covered, it's a repetition. Maybe that's what we should verify, Chair. That was my input. Thank you.
Advocate, is that the section?
Chairperson, sorry, sorry to I've now read this piece, Chairperson, and I am in agreement we are covered in that piece. Thank you, Chairperson. Sorry, apologies for interrupting.
Can we now move? Thank you very much. Advocate.
Chairperson, so just for purpose of that showing out, there's several references in section 73 to the safety and security standards. And this one does go into far greater detail. And if we go just to our bill, if we have a look here, just to double check on the amendments. So Chair, in the bill, there was some amendments proposed to section 73, but members will see here the references to safety and security is retained. And the department has added the additional requirement of the environmental protection requirements that they need in there as well. So Chair, then I'm just gonna get back to my spot. So our next one is clause 26, Chairperson. It amends section 104 of the Principal Act. Just want to get to 104. 104 deals with the National Aviation Security Committee. So the proposed amendment suggested here is for paragraphs A and B. Just to show members, there is A and B. So the new change will be the Director General of the department with the addition of or any person designated by him or her. So just to show members, A just referred to the Director General of the department. And then for B, they are proposing that we substitute reference there of the minister to change it to the Director General of the department. So an official responsible for national air transport facilitation designated by the Director General of the department, not the minister. Chair, then there's a further proposed substitution for G and H. This will be consequential because the reference to the Director of Civil Aviation has been changed to Commissioner. And they are taking out this reference in G of the minister to refer to the department. So G used to read a person designated by the director after consultation with the minister. These are all linked to the composition of the National Aviation Security Committee, Chair. Then just a change to H, an official designated by the Director General from an organization responsible for state security. Again, Chair, just as we did with the reference to the Minister for the Department of Minerals and Energy, they're proposing the change to take out the old department references and just rather replace it with responsible for state security and an N responsible for international relations because of the changes that we do sometimes see in the departments. So Chair, that's the change there to G and H, and to N, it's similar to the department references there. Chair, they are proposing a deletion in subsection 1 of paragraph J. paragraph J used to read, an official designated by the Director General, South African Secret Service. That is most likely because it all falls under state security as well there, Chair. Then on E, they are proposing a substitution for subsection 4, just to show members what subsection 4 used to look like. Subsection 4 used to read, in the process of the establishment and development of the policies as contemplated in section 103, where any matter which may affect any stakeholder consult with the relevant stakeholder or stakeholders in the aviation industry. So the proposed change is just the correction of adding the National Aviation Security Committee there, Chair. Then they are proposing a new additional subclause 5, a person designated by the Director General in terms of subsection 1A must be an employee of the department and must possess the necessary expertise to chair the National Aviation Security Committee. So Chair, again, 1A is the Director General of the department or any designated person designated by him or her, who shall also be the chairperson of the committee. So Chair, that is the composition of the National Aviation Security Committee. I'm going to try and leave it on the screen just a little bit for members before I stop share to make my notes, Chair.
I normally take the first hand that I see, and I can see the hand of Honorable Mang.
Chair, thank you. That is correct. Although, to be honest, I'd forgotten to drop it, but I wanted to raise my hand. Chair, Advocate, if you may, there's that 25-1, somebody who's appointed by the DG. I'm sorry, Advocate, just go back there. Still trying to open my separate one. Yes, that is.
I thought you had gone up to the mountain, and seemingly your mountain is those mountains of Joburg that we know have problems. The man-made one, Honorable Mang. So we have lost you in the process. Chambers. We will take him when he comes back. Honorable Magdi.
Chairperson, thank you. I think if I can also interject here, Chairperson, I think it's what Honorable Mantu was going to say was about the appointment of any suitable person by the director. It means I think I would like to go to that. If I think now I can just go back to that section there, please, Chairperson. I just want some more clarity, maybe from the department, on that any person, Chairperson.
Your clarity is on any person, not the appointment by the director, not the minister.
Yes, thank you, Chairperson.
Okay. Advocate Masombuga.
Thanks, Chairperson. If you look at clause 26, that amend section 104A. There we are saying the Director General of the department or any person designated by him or her, who shall also be the chairperson of the committee. This is similar to when we are putting a departmental representative in any board. The Director General will designate an official of the department to sit in that board if he's not going to personally sit. That is the intention. And the whole section amendment, Chairperson, is aligning the act with the latest developments by making appropriate current references to departments, because the names of the departments changes now and then, and we are avoiding to literally spell them out, because once they change, they necessitate the amendment of the act. Therefore, we better say the department responsible for transport purposes rather than saying the Department of Transport, because if the title changes, then it becomes a problem for the act. Thank you.
Thank you very much. McD, are you answered?
Yes, thank you, Chairperson.
Honorable Manu, are you back with us?
Yes, Chair. I had to switch a gadget. Quite is a challenge for me. However, my concern was it being a security committee. The person doesn't seem that the DG, I assume the DG would have gone through a security clearance for him or her to be appointed in the first place. However, it doesn't seem like this person is going to go through a similar process of security clearance. That was the point I was raising, Chairperson. I'm not sure if it is covered or it can be covered somewhere else. Thank you, Chair.
Advocate Mazombuga.
Chairperson, officials of the department, especially senior level, are required in terms of the Public Service Act to undergo security clearances. So we do have security clearances, and when the DG appoints you or designates you, obviously for you to be employed, you are already having that security clearance. Thank you.
Okay. At the same level as the DG advocate?
Yes, Chairperson.
Thank you very much. Any other matter on this, honorable members, as Honorable Mangulu lowers his hand?
And it's a fresh raised hand, Chair.
Okay, sure. Honorable Mangulu.
Thank you. Thank you, Chair. I hear advocate, but that's an assumption, or somebody who's in the department who knows that. It is not obvious, Chair. It doesn't say that the DG will appoint a senior manager. It says any person. And nowhere does it say that person would have a security clearance. So having heard advocate, I think we need to be very clear that has to be a consideration. Whoever the DG decides to appoint, no issue, but that person must have. It doesn't say there, or it's not given that the person would have been coming from senior management. Thank you, Chair.
So your proposal is that that sentence should be enriched.
That is correct, Chair. Having listened to Advocate Masombuka, I'm even more convinced that it has to be enriched to protect the integrity of the security committee, to the effect that that person must also be in possession of a similar clearance as that of the DG. Thank you, Chair.
Members, any member who supports the proposal by Honorable Manu?
Chair, good morning.
Good morning.
I do second the proposal by Honorable Manu. Thank you.
Honorable Figile, your voice is like Tandiwe Pondo's voice. Thank you very much. Mtonga.
I can raise it, Chair, if you want me to do so.
No, I was saying
Thank
your voice seems like Tandiwe Pondo's voice. So I thought Tandiwe speaking. But thank you, I've heard you supporting. Thank you very much. Anybody who has a problem with this? Thank you very much. Advocate Nell.
Chair, I think because the new subclause 5 links with that appointment, the drafters can possibly just look here to expand the necessary expertise that is stated here and possibly consider the request there to add the as well as necessary security clearance. Because if from my experience, having been in the SMS, not all SMS members carry the same level of security clearance, Chair. So because not all of them, for example, will be working with cabinet memos that have top secret clearance. So Chair, it might just be the necessary expertise and security clearance that the drafters can just add in here that might assist with that clause, Chair. Chair, then going to the next clause is clause 27, where it is an amendment to section 108 of the Act. 108 is designation of staff of the National Aviation Security Committee by the Director. It used to read that the Director shall designate personnel in the Civil Aviation Authority to assist the National Aviation Security Committee in its work. So this is the Secretarial Administrative Assistance, Chair. Chair, let me just, the slip of the mouse here closed my document. Let me just get the bill quickly, Chair.
I thought this is Tuesday, Advocate, is not Monday.
Chair, my fingers are just too quick for the laptop. I think that's the problem here.
Okay.
Okay, there we go, Chair. Just get my sizing up for members. So the new clause, Chairperson will read designation of staff is removed there. So it's designation of Secretariat of National Aviation Security Committee. Then Chair, this is a consequential amendment after the heading has been amended, just to take out the reference of Director and substitute it for Commissioner. The rest of that clause really is the same. It's just the heading and reference to Director that's changed there, Chair.
You want me to test, or are you still continuing?
And no, Chair, you can get members' views on this proposal, Chair.
Honorable McDonald.
Chairperson, I'm okay with that, Chairperson. I've got no problems with it.
Thank you very much. Anyone who supports that we should carry on? Honorable Manu.
I do support, Chair. Thank you.
Thank you very much. Any member who has an issue fundamentally on this matter? Going once, twice. Thank you very much. Advocate Almanel.
Chair, then our next clause is clause 28. It wants to amend section 110. So this will be an amendment of the heading again, as well as amendments to subsection 1. So Chair, just to show members what 110 looked like. 110's heading was determinations by Minister. And subsection 1, the Minister must, in consultation with Civil Aviation Authority and with the concurrence of the person in charge of a designated airport, approve the appointment of the person responsible for the execution of the security program of such designated airport. So Chairperson, the proposed amendment there is to the heading, appointment of person for execution of aerodrome. This is where this A-list reference aerodrome must be changed to aerodrome. That N must be changed to an M there, Chair. So it's appointment of person for execution of aerodrome security program. And then subclause 1 should change. The Commissioner must, in consultation with the person in charge of a designated aerodrome, approve the appointment of the person responsible for the execution of the security program of such designated aerodrome. So, Chair, the proposed amendment here takes out the reference of the minister, and it takes out the reference of the consultation with Civil Aviation Authority with concurrence. So, Chair, that's 4 members there to consider.
Thank you, Advocate. Honorable McD.
Chairperson, thank you. Chairperson, can I just get some clarity on that specific section of why are we removing the in consultation with this, because that is a specific person that will be appointed on another airport, for an example, that it is designated to work with the security of that airport. I'm just, can I just get some clarity maybe from the department on why are we removing the in consultation with the South African Civil? Because it seems like now somebody else can, that the department's taking over the function of who's being appointed on a private airport. I'm a bit confused there, Chairperson, so maybe if I can just get some clarity. Thank you, Chair.
Advocate Masumbuga.
Thanks, Chairperson. The commissioner, remember, is representing the Civil Aviation Authority. Therefore, he cannot necessarily consult himself or herself. Here, the commissioner must, in consultation with a person in charge of a designated aerodrome. I think the wording is very clear, Chairperson. If a person can remember that the commissioner is the senior employee of the authority, Civil Aviation Authority.
Thank you, Advocate Masombuga. Is that clear, Honorable McDonald?
Yes, Chairperson, I'm clear. Thank you very much. As I lower my hand.
Thank you very much. Any second that we must move. I can see Honorable Hansen is here with us. Thank you very much. Welcome, Honorable Member Baba Manu.
I move to support the proposals, Chairperson.
Thank you very much for your kindness and commitment. Advocate Almanel.
Chairperson, then our, just to point to members here on the A list. So obviously then the aerodrome correction will stand. So that reference there is corrected. So that will be the only additional amendment to clause 28. Then I can move on here to the next amendment, Chair. The next one is on an amendment of section 111. The heading, subsection 1, and an amendment to subsection 2. So just to show members what the old section 111 looked like. The heading was aviation participants required to have national aviation security program. The new proposed heading, aviation participants required to have aviation security program. So it's just this reference here to national is removed. Then for subsection 1, the new proposal is the following aviation participants are required to develop and implement an aviation security program. So they have to develop and implement it. The have is being removed there. Subsection 1 used to read, following aviation participants are required to have a national aviation security program. Chair, then the next amendment proposed there is to subsection 2. It's a substitution of the old subsection. So old subsection 2 read, any aviation participant who fails to comply with subsection 1 or fails to comply with the National Aviation Security Program instituted in terms of subsection 1 is guilty of an offense and on conviction liable to a fine or to imprisonment for a period not exceeding 10 years or to both such a fine and imprisonment. The new clause, any aviation participant who fails to comply with subsection 1 or fails to comply with the Aviation Security Program instituted in terms of subsection 1 is guilty of an offense and on conviction liable to a fine or to imprisonment for a period not exceeding 10 years or to both such fine and imprisonment. So Chair, that is the new changes or the changes to section 111 for members.
Thank you, Advocate, for coming back. Members, let me see if we have happiness here. Ubaba Ulisa wakwaManci. Unmute yourself, sir.
Askis, this Kwakwa business is a challenge. Happiness, Chair. Sorry for that.
Thank you very much. Honorable member, you look honorable indeed. Thank you. Any seconder?
I second Chairperson, Chris Hunsinger. Good morning, colleagues. My apology for joining late, Chairperson.
Thank you very much, Honorable Chris Hunsinger. This room was not nice without you. Thank you very much that you are here. Thank you. Any member who has an issue? Going once, twice. Thank you, Advocate Alma Nell.
Chair, then our next clause is clause 30. It deals with an amendment of section 112 of the Act. Section 112 dealt with the offences. So the amendment proposed here is to subsection B. Contravenes or fails to comply with any provision of the National Aviation Security Program approved by the Minister, and whereof the contents have been brought to his or her notice, is guilty of an offence and shall be liable on conviction to a fine or imprisonment for a period not exceeding 10 years, or both such fine and imprisonment. So Chair, here the reference changes from a safety plan to the National Aviation Security Program, slightly different to the previous clause. And the reference to the fine amount has been removed because most of our fines are determined then by the courts. Chair, just to show the old section 112, fails to comply with provision of a safety plan approved by the Minister, and then the 50,000 there. So Chair, above and beyond that, they have to have a security, the security program or security plan. I just want to go up to our previous one. They each have to develop and implement an aviation security program for section 111. Section 112 then also requires them to comply with the National Aviation Security Program. So Chair, I hope that assists to clarify the difference in these two members, but I'm sure the department can also assist further there, Chair.
Thank you very much, Advocate. Let me see any member who wants to express happiness, or any other issue. Baba.
Chair, thank you. I support the proposed amendments.
Thank you very much, Chambers.
Seconded, Chairperson.
Thank you very much, Baba or McDonald. Any member was an issue? Going once, twice. Thank you very much, Advocate Alma Nell.
Thank you, Chair. I just enlarged the document a little bit because our next reference to the A list before members is only quite a way away. So this will hopefully assist us all with the reading. Chair, our next clause is clause 31. Clause 31 seeks to amend the heading of chapter 7. So Chair, here's the heading of chapter 7 on the Principal Act. Used to read monitoring and enforcement of regulatory compliance by Civil Aviation Authority and issuing of compliance notices. Proposed amendment there is monitoring and enforcement of regulatory compliance by Civil Aviation Authority. So it removes and issuing of compliance notices. Chair, I'm just going to do clause 32 as well. Then members can consider both 31 and 32 at the same time. The amendment to section 113 of the Principal Act will be subsection 1A. So subsection 1A of 113. 1, in order to monitor and enforce compliance with this act and subject to conditions of his or her appointment, a person referred to in section 88(1) may at any reasonable time and without prior notice, without a warrant, enter into any aircraft, place, or premises. So here, Chair, it just takes out any reasonable time. So this will now change to, in order to monitor and enforce compliance with this act and subject to conditions of his or her appointment, a person referred to in section 88(1) may at any time and without prior notice, without a warrant, and then they'll be able to enter. Chair, obviously the reference to the warrants above, I just want to take members to section 88(1) because I believe the reasonable time will be in 88. There we go, Chair, 88(1). So this will allow the inspectors and authorized persons the designation thereof in 88(1). Chair, they are then authorized and designated again to perform their powers as inspectors. So Chair, the reasonable time is normally covered in the, just can't get the cross-reference now here, Chair, but it is in the search and seizure documents. But Chair, as soon as they get the warrant and the order from the courts, they are allowed to enter the premises for their inspections. But the department can just clarify here if there's any concerns about the removal of reasonable time. Because as soon as they get the warrants, then they have to go and issue, but this is also without a warrant that they can go and enter the premises, Chair. So Chair, for members, clause 31, the amendment to the heading, and clause 32, the removal of reference to reasonable time.
Thank you, Advocate. Honorable McD.
Thank you. Just, I don't know.
We want to hear your voice.
Apologies, Chairperson. Apologies. The technology is not well today. Chairperson, I don't have any vehement issues with it. I do have an issue with the without a warrant, Chairperson. under the South African Constitution, when the police come to your house, they can't just search your house without a warrant. They can't just attach documents without a warrant. And I think the removal without a warrant, saying that stipulating without a warrant is unconstitutional, Chair. And I'm not 100% sure, Chairperson. If I can get proper clarity on that, I might change my mind. But at this moment, I think without a warrant is overstretching. Thank you, Chairperson.
Overstretching without a warrant. Honorable Manu.
Yes. Mine was going to seek clarity as to, by the look of things, both those proposed removals or deletions don't seem to have any material effect, but I would have loved to know what is the reason from the department. But generally, they don't look harmful at all. The one might maybe raise a question: what is reasonable, what is not reasonable? Although I was not to comment on what my colleague has just said, I'm of the view that it has always been like that without a warrant in the Principal Act. I'm assuming if an inspector just got information and a plane is about to take off and they need to go and stop that plane for security reasons, or rather safety reasons, safety and security, it will be impossible for that inspector to go and get a warrant by that time. And I think those who want to abuse the airspace and other things might use that loophole should they know that these people need to have a warrant. That is just my view on what my colleague has said. But my fundamental one is the reasonable. What is the meaning? What is the impact or the reason why we are removing it? But generally, it looks harmless in my view. But just to clear our minds. Thank you, Chair.
Thank you very much, Chambers. Ubaba, advocate, okwamasumbu, asithokoze, advocate.
Thanks, Chairperson. We have deemed it not necessary to keep the word reasonable because the action that must be taken by the inspector must be eminent, because if he's not acting instantly, then the purpose of searching might be defeated. Like it has just now explained that it will be time consuming to go and apply for a warrant and come to search a plane that is landing all of a sudden. And if we don't put this provision in, obviously the wrongdoers or the offenders will capitalize on the fact that it is just going to be impossible for the inspector to have a warrant when we are landing. When it comes with that particular warrant, the crime shall have been long committed. Thank you.
I hope that convinces us, Honorable MacDonald.
Chairperson, I've got no problem with the inspection without a warrant, but the seizure, it states seizure of documents on the previous part there, that without a warrant, Chairperson. Seizure of documents and related information does not fall under the inspection. That was my concern. But if that is it's fine, because it says that any person who control over the custody of any book, document, or thing, Chairperson, without a warrant, just to come and take people's documents, I'm worried, Chairperson. But yeah, I'll succumb to the majority must rule, Chairperson.
Ubaba waka man.
Thank you, Chair. I will be the majority, Honorable McD, and ask that. I mean, we are dealing with a totally different environment. It's not like somebody just coming to a house. Aviation, as we have already alluded earlier, it's a very serious space. And I would plead with you that we leave it as it is. It sounds to me very reasonable to protect our airspace and us. But going back to the reasonable deletion, I accept the explanation by Advocate Masombuga, and I move for the acceptance of those two deletions, removal of reasonable, and the change of the heading as proposed. Thank you, Chair.
Chairperson, I remove my objection, and I agree with what Honorable Manchu said in light of the e-submissions and to keep the airspaces in South Africa safer. Thank you, Chairperson.
Thank you very much, honorable members. Thank you very much, Mr. Frank Jenkins. You may feel that I have not recognized you. Let me recognize you.
Chairperson, good morning, honorable members. Good morning. I wanted just to come in and assist Mr. McDonald on the issue of the warrant and the right to privacy. If he's satisfied, sir, that's all good. When we deal with, I think maybe to allay his concern or to understand it better, when we're dealing with a licensed premises, which is sort of under a license, your right to privacy as operating within that space has already been eroded. For instance, a bank, financial institutions and such. So there, the issue of a warrant and a search and seizure has a lower standard, if I may put it like that, as when we get to a private house. And in fact, when we are with a private house, the issue of a reasonable time is actually quite important. So I think this amendment is in order, Chair, but maybe just to assist members to understand why it is a lower threshold, the right to privacy there. Thank you, Chair.
Thank you very much. Are you also advocate, Frank?
Chair, I'm an advocate.
Thank you very much.
You're welcome, Chair.
Thank you very much, Advocate Jenkins. Advocate Almanel, can we continue?
Yes, Chair. We are on clause 33. Clause 33 seeks the deletion or repeal of section 114 in its entirety. So just to show members the section 114 on compliance notices. Any person conducting an inspection as contemplated in section 1131 may issue a compliance notice in the prescribed manner to the person in charge of the premises or to the person determined to be responsible to take appropriate corrective action in order to remove or rectify such condition if any provision of this act has not been complied with. So, Chair, it goes all the way up, keeps cross-referencing to 113, goes up to subsection 7. Chair, I think if I just go back, we have dealt with compliance notices before. So the department can just highlight their need here for the deletion of section 114, Chair.
Baba Masombuga. Advocate Masombuga.
This one. Thanks, Chairperson. Clause 34 amends section 116 of the Act to clarify the powers of inspectors with regard to prohibition of certain activities.
Sorry, Advocate, it's clause 33, repeal of section 114. You are
Okay,
at
no,
34.
Thanks very much. The provision of this section were never implemented in practice, and when considered in light of the existing practice, they are impractical in some respect, especially when they indicate that non-compliances constitute an offense, implying that the criminal process must be invoked. That is the explanation.
Thank you. Advocate Almanel, you want me to test the happiness of the members? I'm ready.
Absolutely, Chair. If my members are not happy, I'm not doing my work.
Members, let me see hands. Happiness. Lawrence McDonald.
Chairperson, I'm in support of the amendment, Chairperson. Thank you.
Thank you very much. Baba Uchambas.
Seconded, Chair.
Thank you very much, Chambas. Advocate Almanel, my members are happy. You can continue.
Thank you, Chair. Clause 34 is amendment of section 116. There is a substitution of the following. So I'm just going to show members what 116 looks like. It's on the prohibition on exercising of certain privileges of any aviation certificate, permit, authorization by authorized officers or inspectors. So we are doing a substitution in subsection 1. Such officer or inspector may prohibit the aircraft from being flown or prohibit the holder of an aviation certificate, a permit, or an authorization from exercising the privileges of such aviation certificate, permit, or authorization. So, Chairperson, it is this paragraph that is being amended just after B. And then the second proposal under this section is to delete subsection 3. So just to show subsection 3 to members, it was the prohibition in section 1 may not be imposed for a period longer than 24 hours. So, Chair, that is the proposed amendment. This will also link with those urgent matters where they do need to ground an aircraft, Chair, for whatever reasons they may have, whether it's the security related reasons or others. Then if we can get members' view on this, and I'm sure that the department can also clarify if there's a need to clarify that one, Chair.
Thank you. As talker was advocate to Masombuko.
Thanks, Chairperson. Clause 34 amend 116 of the Act to clarify the powers of inspectors with regard to prohibition of certain activities. The restrictions relating to the time period within which a prohibition may be issued is impractical because a prohibition may be as long as the event with which cause it exists. Thanks, Chairperson.
Thank you very much. Chambers.
Chair, I didn't, well, I had advocate now. My original question was going to be, does it mean then that prohibition can be limitless? Now advocate is saying as long as it requires. I don't know what that means. Maybe an example could help, you know. I thought 24 hours I was going with, but maybe some limit of time. Does it mean it can be a year? Does it mean it can be 2 years? Is there no ceiling of this particular prohibition? Maybe that is the question that I must ask directly. Thank you, Chair.
Advocate Masombuga.
Thanks, Chairperson. Can I defer to leave us to give an example and give the practical perspective of it?
We are,
Through
now
you,
on,
Chair.
we are now on level 1. Is leave us back home, advocate?
Not yet, Chair. He's still packing.
Okay, let me leave it at that. Mdungwa lapho eCanada. Good morning if it's morning. Masukuzwe baba.
Thanks, Honorable Chair. the prohibition will last as long as what caused the prohibition has not been rectified. Honorable Mangu, is like if a driver of a commercial vehicle, the PDP has expired, but still has a valid license, so will be prohibited from driving the commercial vehicle as long as it does not have a new PDP. So that is the case. Because the prohibition of a flight will be because something which will cause the flight to be fly unsafely or to contravene security exists. So as long as that has not been resolved, the flight will still be prohibited from flying. Thank you.
Thank you, Livas. Honorable McDonald.
Chair, thank you. I was going to help Honorable Manchu with it.
Yeah, so he's already. So from your side, suffice.
I'm fine. It's correct, Chairperson, because we can't allow a plane to be unairworthy and then within 24 hours the plane still because of the time limit, and then we are faced with an aircraft accident later that day, Chairperson. So I'm in agreement with the amendment, Chairperson.
Anyone, as you lower your hand, Honorable Member McDonald. Thank you very much. Anybody who has an issue? Going once, twice. Advocate.
I've got an issue. Livers didn't answer that morning or evening. But other than that, I support the amendment.
Yeah, we'll go back to Livers. I know it's still very dark there, and we are stealing his sleeping time, but it's okay. Advocate Almanel.
Chair, the answer lies in the Principal Acts 116 subsection 2, because it does say here that it may be withdrawn when the authorized officer is satisfied that the cause for such prohibition has ceased to exist. So if you look at it, actually the old 2 and 3 was in a sense contradictory to each other, because if 2 lasted longer than 24 hours, then you wouldn't actually be able to implement subsection 3. But Chair, then just going to our next clause is clause 35. It's the amendment of section 118. 118 deals with appeal against decisions of authorized officers, authorized persons, and inspectors. So, Chair, the amendment is to the heading first, appeal against decisions of authorized officers, authorized persons, or inspectors. Then the next amendment is to subsection 1. Any aggrieved person or entity whose rights have been detrimentally affected as contemplated in section 1172 may appeal against a decision of an inspector, authorized officer, or authorized person to inter alia. So, Chair, they've just included the reference to inter alia. Then, Chair, deletion in subsection 1 of paragraph A and B is proposed. So A and B, just to show members there, was these 2 are proposed to be deleted. Then moving on here, there is a substitution for subparagraph C, 1C. So they remove cancel. So it would be a decision to suspend or endorse such persons or entities' registration license certificate. Show members, that is what C used to look like. Right there. Then there is also a proposed deletion of D. D read issue a compliance notice or refusal to issue compliance certificate in terms of section 1141 and 2. Then, Chair, there is a substitution proposed of subsections 2, 3, 4, and 5 with the following. So, Chair, this is the consequential amendments of director to commissioner. And then there's an amendment here where it used to be 3 days. They are proposing that the commissioner must, within 14 days of receiving such appeal in writing, confirm, vary or set aside the decision of the authorized officer, authorized person or inspector. Then again, we have commissioner here in 4. And then in subsection 3 here, they are proposing a move away from 5 days to 30 days. May appeal against such decision within 30 days of receipt of the reasons referred to in subsection, that will now be 4, to an appeal committee contemplated under section 122. And then, Chair, there's also a proposed substitution in subsection 6. It's the consequential amendment of director to commissioner. And then there's a further substitution of sections 7 and 8, the consequential amendments there, Chair, of director to commissioner, and then just correction of the new subsection numbering, and then a deletion of subsection 9, just to show members then what 9 used to look like. Subsection 9 used to read, an appeal lodged in terms of this section does not suspend the decision of the authorized officer, authorized person, or inspector. Chairperson, that is quite a few amendments and changes there. I think the biggest one is the time frames that we really do see, the deletion of subsection 9. Most of the rest are consequential amendments, but Chair, this is now for members to just give their input on whether they are happy with these, Chair, and if you will, need any clarity, the department can surely provide that for members as well, Chair. Clause 35.
Obaba Unsinga, thank you, Advocate.
Thank you, Chairperson. I think it's fine. The changes are caused by, is triggered by structural change. Interesting that the time limits from 3 to 14 and from 5 to 30. When we were youngsters, they told us with computers, everything will be quicker and faster, but now it seems to be going contrary to what we were told, but such is life. It's definitely more complex and a lot more complicated, but I don't have a problem, Chairperson. I propose that we accept and move on.
Thank you very much, Honorable Member. Any seconder?
Seconded, Chairperson.
Thank you very much. Any issue, any contra view? Thank you very much. Advocate Almanel, let's move.
Chair, clause 36 will amend section 119. Section 119 is the appeal against refusal, cancellation, endorsement of medical certificate or declaration of unfitness. So, Chair, again, there's quite a few amendments here. So there is the deletion of the word or at the end of subparagraph Roman number 3 in 1A. So this or here is deleted. Then, Chair, the substitution, the or goes to after 4 because there's a new 5. So this or moves here and we get after certificate and we get a new subclause 5. The new subclause is to read a decision by a designated medical officer to suspend or endorse his or her medical certificate. And then, Chair, here is another addition here. May appeal against such decision or endorsement to the director, which is now changed to commissioner, in the prescribed manner. And on the payment of the fees prescribed. There's a deletion here by the minister because there's certain fees and manners that can be prescribed by the commissioner as well. Then, Chair, there's a substitution in subsections 4 and 5. So again, it's consequential to add commissioner, but there's also the addition of confirm or set aside the decision. Then, Chair, for the new 5, any person affected by a decision referred to in subsection 4 may appeal against the decision to the appeal committee. And then there's a deletion of subsections 7 and 10. So, Chair, just to show to members what 7 and 10 looked like. 7 was the person appealing in terms of subsection 1 is entitled to legal representation. And 10 was an appeal lodged in terms of this section does not suspend the decision or endorsement in respect of which the appeal is lodged. Chair, that is the proposed amendments to section 119. We can just get members' views, queries, and input on this, Chair.
Thank you, Advocate. Agbareliede McDonald.
Dankie, voorsitter. Ek het geen probleme met die wysigings op hierdie oomblik nie. Ek dink ons kan voortgaan. Dankie, voorsitter.
Ek waardeer dit baie, Agbareliede. Enige iemand wat iets wil sê?
Ek ondersteun dit ook, voorsitter. I support it. Thank you, Chairperson.
Dankie baie, Agbareliede Piet May. Advocaat Almanel, kan ons voortgaan?
Yes, Chair, then clause 37 will amend section 120. So members will see quite a few of these amendments refer to the change again, the consequential change of director to commissioner. There's also a change here in subsection 1. Any person or entity aggrieved by a decision referred to in subsection 2A to E, taken by the commissioner. And then again, here they can file their appeal within 30 days. So this one links up with the previous changes that have been made as well. Chair, then just here, there's a substitution here for paragraphs A and B. So the new A will be a decision taken in terms of section 1183, and B, a decision by the commissioner to refuse such person or entity's application for registration. So we are removing the exemption there, and as well as this one we are removing. Again, here the exemptions are being removed in those paragraphs. Chair, there's a proposed deletion of subsection 2, paragraph C and F, just to show members what C and F used to look like. A decision taken in regard to the designation or withdrawal of a designation as inspectors, authorized officers, or persons, and D, we're looking at C and F. F is the issuance, amendment, or withdrawal of technical standards for civil aviation in terms of section 162. So C and F is proposed for removal. There is a new subsection 3 proposed, again, the consequential change here to commissioner. And then it's just because we've removed F, there has to be a reference there to E, Chair. So that's also a consequential amendment if this deletion is agreed to by members. So Chair, that is clause 37 for members.
Thank you, Advocate. Members, let me see happiness or any other view.
Chairperson, if I may, I'm in support of the amendments, Chairperson.
Thank you very much, Honorable McDonald, Honorable Manu.
Ek wel gesê soos aanbeveel voorsitter, maar nou sê ek ondersteun ook. Dankie voorsitter.
Wow, ek het dit nie geweet dat u kan so sever Afrikaans praat. Dankie agbare lede vir die ondersteuning. Advokaat Almanel, kan ons voortgaan asseblief?
Yes, Chair. Clause 38 is proposing a new section to the Principal Act. So we will now be including section 120A, effect of appeal on decisions. 120A, in order not to jeopardize aviation safety and security, an appeal lodged as contemplated in sections 118, 119, or 120 does not suspend such decision. So, Chair, if members recall, in the previous sections, we removed those references in each of those sections, and we see it here compiled in one encompassing section, Chair. So that is then for the members just to give an indication if they are okay with the new section there.
Honorable members, Honorable Chris Hansinger, thank you very much for support. Any seconder?
Seconded, Chairperson.
Thank you very much. Thank you very much, Honorable Member. Advocate Nell.
Chair, then clause 39 deals with section 121. So we have a heading change here, submission of appeal. So we take out reference here to appeal committee. And then Chair, the section will now read, any person or entity who submits an appeal to the appeal committee must submit such appeal in accordance with the requirements prescribed and payment of the fees prescribed. The appeal may be brought by the person or entity concerned or a duly authorized employee or legal representative of the said person or entity. So Chair, that is clause 39. For members, this is what the old section 121 looked like. And that is what our new 121 will look like, Chair.
Thank you very much, Advocate, for coming back to me. Honorable members, Honorable McDonald.
Chair, I propose that we support that amendment, Chairperson.
Thank you very much. Any seconder to that? Honorable Hansinger, thank you very much. Advocate Nell, can we move?
I'm going to, again, just combine clause 40 and 41. 40 is a substitution of heading for chapter 8. That will now be the appeal committee and not committees. So that is clause 40, and then clause 41 is an amendment of section 122. Chair, there is 122. So obviously this amendment in the appeal of multiples to a single committee is going to require consequential amendments. So here 122.1, the minister must establish an appeal committee composed of members appointed on a part-time basis to consider and decide appeals. Chair, it indicates here the chairperson's duration of appointment, the experience required, as well as 5 other members or not less than 5 other members for that appeals committee. Chair, there's a proposal here to change sections 5 and 6. So 5 here, we have a consequential amendment to the reference to the commissioner. And then we have an employee of the Civil Aviation Authority, member of Civil Aviation Authority Board, or a member of any committee of the Civil Aviation Board may not be appointed as a member of the appeal committee. New 6, a person appointed under subsection 1 may not participate in the consideration of an appeal if he or she has any direct or indirect personal interest in the outcome of that appeal, or if he or she, his or her partner or immediate family has business or personal relationship with the appellant or the appeals partner or the appellant's immediate family member. And there's a deletion of subsections 9, 11, and 12. And Chair, just to show members what 9, 11, and 12 looks like or looked like. 9 was the minister may, if performance of an appeal committee is unsatisfactory, terminate the period of office of all members of that appeal committee. 11, minister must, subject to subsection 3, appoint a temporary replacement member for an appeal committee. If before or during an appeal it transpires that any member of the appeal committee, then it deals with their interests or illness and absence. And 12, National Treasury is responsible for the expenditure of an appeal committee. So Chair, that is the clause 40 and 41 for members, 40 dealing with the heading, and then 41 dealing with section 122.
Thank you, Advocate, for coming back to me. Honorable members, clause 40 and 41. Let me see any happiness. Honorable Nansinga, thank you very much. Honorable McDonald.
Second, Chairperson.
Thank you very much. Thank you very much. As you lower your hand, Honorable McDonald, can see Honorable Mango also supports. Advocate Almanel, let's forge ahead.
Thank you, Chair. Then clause 42 deals with section 123. Just to show members, there is section 123. There is an addition here, so we're not taking anything away from the Principal Act. We're adding any appointed member who holds any office or office in or under any government entity, administration, or department, or in or under any institution or body that is wholly or partially. Yes, Chair.
Any appointed member who holds any post or office. You said any office or office.
Sorry, Chair. Any post or office, and Chair, or in or under any institution or body that is wholly or partially funded by the state, is not, in respect of the duties performed by him or her as a member of the appeal committee, entitled to any payment. And Chair, again, this links to that previous discussion we had on the payments of state employees or employees under the public service, Chair.
They will only get subsistence. Thank you very much. I still remember it.
Yes, Chair. We link it back to that one. If members are happy with that, we can go to clause 43.
Honorable members, let me see happiness on clause 42. Thank you, Honorable Manu. I can see you have joined now the new technique. There goes Honorable Hansinger. Thank you very much. Happiness is here with us. Can we move, Advocate, to
Yes,
43?
Chair. Clause 43 is an amendment of section 124. Chair, just to show members, there's 124. It's on a quorum and meetings of the appeal committees. Obviously, all reference to committees will have to change to appeal committee. So, Chair, here, the new subsection 1. An appeal shall be considered by at least 3, but not more than 5 members selected from the list of appointed members. The chairperson of the appeal committee shall preside over the meetings of the appeal committee. If the chairperson is unable to attend a meeting, he or she shall designate a member who has legal qualifications and experience as a chairperson of that meeting. Then a substitution of subsection 3. The rules and procedures for the appeal committee are determined by the minister. And then subsection 4, addition D, call an employee of the department to clarify policy or legislative provisions. So, Chair, that is clause 43, proposing those amendments to section 124.
Thank you very much, Advocate. Let me see happiness from the honorable members. Thank you, Honorable Manu. Any seconder? Thank you very much, Honorable Hansinger, for seconding. Thank you very much to both of you. Advocate Almanel.
Chair, clause 44 deals with the decisions of appeal committee. So, Chair, the new section 125. 125 was just a one-sentence provision. So now we have a bit more meat. 125 will now read, the appeal committee may confirm, vary, or set aside any decision against which an appeal has been lodged in terms of section 121. A decision of the majority of the members hearing an appeal is the decision of the appeal committee. And 3, the chairperson of the appeal committee shall have, in event of an equality of votes, a casting vote in addition to a deliberative vote. So, Chair, that is clause 44 for members' consideration.
Honorable members, there we are. Let me hear your views. Honorable Pete May.
I support the amendment. Thank you, Chairperson.
Thank you very much. Any seconder, honorable members? Honorable McDonald.
I'm supporting Chairperson. I've got no problem. Thank you, Chair.
Thank you very much. Advocate Almanel, can we move?
Okay, Chair, our next clause 45 on section 126. General provisions regarding appeal committees, which is now appeal committee. So Chair, 126 will change subsection 2. A decision of the appeal committee contemplated in section 125 must be furnished to the commissioner and the appellant in writing within 21 days of the hearing of the appeal. And there is a substitution of subsection 9 proposed. The appellant is entitled to legal representation at an appeal before the appeal committee. So, Chair, this is what section 126 looked like. It was quite long here. Went up to subclause 9 there. Chair, those are the proposed amendments to subsection 2 and 9 of section 126 in clause 45 for members.
Thank you, Advocate. Let me see happiness from the members. Any take, honorable members? Honorable Lawrence McDonald, thank you very much. I can see you're trying a new technique. You'll come all right with time. Any seconder?
Seconded, Chairperson, with old technique.
New technique, Honorable Hansing, I also support. New technique, thank you very much, Honorable Advocate Almanal. Let's forge ahead.
Chair, clause 46 substitutes the old section 128. So again, Chair, consequential amendments here with reference from committees to committee. And then administrative work of the appeal committee must be performed by employees of the department. Chair, since we have the secretarial duties amended in that way earlier, the old section 128 read as follows. So that is there for members to consider. Before we move on, that's clause 46.
Clause 46, thank you very much, Advocate Almanel. Let's see what members are saying. Back to you, honorable members. Can I see happiness in your face, in your gesture, in your hands?
As clear as can be, I support it, Chairperson.
Thank you very much, Akbar Eliede. Understanding, Honorable Hansing, thank you very much. Advocate.
Why are you ignoring me and my thumbs up?
No, your thumbs up is not visible. I would really want to welcome you. There you are. You have practiced it properly. Now I can see it. Thank you very much, Honorable Mem. You know, every time when you arrive, you normally do these things. Advocate Almanel, let's forge ahead. Section clause 47, I guess. I'm correct?
Yes, Chair. Again, this is a combination. One amends the heading and the other amends the section underneath the heading. So, Chair, I'm proposing that we look at clause 47 and 48 together. So, clause 47 changes the Chapter 9 heading. Chapter 9 heading used to be procedures for identifying and notifying of differences, issuance of exemptions by director, and interception orders. So the new heading, procedures for identifying and notifying of differences, issuance of exemptions, and interception orders. So we're just taking the reference to the director out here, Chair, because we do have the consequential amendments to change that to the commissioner, but there's no need here to specify that it'll be done by the director. Then clause 48, Chairperson, deals with section 130. Section 130 is issuance of exemptions that will obviously director will change to commissioner. So Chair, our legal team will absolutely make sure that that director is changed in the heading there. This is now changed in proposal to be issuance of exemptions by minister. So Chair, the minister does the regulations that issue the exemptions, and the substitution of subsection 1 is the minister may on good cause show exempt partial or entirely any person or body from compliance with this act on the conditions as the minister may direct. Then substitution of subsection 2A, just before A, in exempting a person or body contemplated in subsection 1, the minister may have regard to. And then, Chair, here is a substitution of B and C. B will now read any serious and imminent risk to aviation safety, security, or environment, whereas that reference in 2B was any serious or imminent risk to air safety or security. So it's broadened now, Chair. Then the proposed amendment sub C, the existence of an alternative means of compliance. And then, Chair, there's the further reference here, reference change in subsections 3 and 4. The minister may not grant any exemption under subsection 1 for a period longer than 180 days, which period the minister may, on an application in writing, extend for a further period not exceeding 180 days. The procedure for the application for the issuance of exemption is as prescribed. So, Chair, those are the proposed amendments in clauses 47 to the heading and 48 to section 130.
Now, let me see what honorable members are going to say. Honorable members, happiness, any other thing? Honorable Manu.
I support the proposed amendments.
Thank you very much. Honorable Mapena, you have mastered the new technique. Thank you very much for supporting. Can we now move? Advocate Almanel, let's forge ahead.
Chair, clause 49 will be amending subsection 2 of section 131. So, Chair, the old section referred to any South African aircraft, and just to show that one there to members, any South African aircraft. And we are proposing that we change that to an appropriate authority of the Republic. That is the proposed amendment under clause 49, Chair.
Can you take both clause 49 and 50?
Yes, Chair. Clause 50 deals with amendment of section 132, subsection 3. So just to show members, subsection 3 of 132, that one right there. So the proposed amendment here is the transfer contemplated in subsection 1 shall not have effect in respect of other contracting states before the agreement between states in which it is embodied has been registered with the International Civil Aviation Organization, ICAO, and that is full stop there, Chair. So they take out the reference here in pursuant to Article 83 bis of the convention or the existence and scope of agreements. So, Chair, it's straightforward compliance here with by the member states. Yeah. So that's clauses 49 and 50, Chair.
Advocate, thank you very much for coming back to me, back to the honorable members. Let me hear your reaction on this one, Honorable Chris Hunsinger.
Chairperson, thank you. In principle, no problem. That Annexure 2 of the convention, which is used as an anchor reference of the appropriate authority of the Republic in section 49, do we have it at hand so that we could just look at that quickly?
Advocate Almanel.
Chair, unfortunately, I don't have the annexure close by to cross-reference that now for members, Chair.
It shouldn't be a problem. It's just that the appropriate authority, without a direct reference as what is available in this reference, in that it refers to a specific place, Annexure 2. I think if we could just get that not on a pre-condition, simply to also get insight into that annexure. Do we have anybody that, Chairperson, through you, is there anybody that can help with this?
Advocate Masombuga, can you help?
Can I check with Mr. Can I check with Mr. Mabasa through you, Chair?
Yes, Advocate. Leave.
Thanks, Honorable Chair. The annexure referred to, I just want to clear that. I can quickly get there. Is it a reference to Annex 2 to the convention or the annexure to the act, which is the convention? I just want to clear that.
There you are. Advocate Nell.
Chair, it would be Annex 2 of the convention as is proposed in the amendment bill, the reference there. Chair, it was the same in the Principal Act. So we just need to get the wording in Annex 2 of the convention and how Annex 2 of the convention explains this an appropriate authority of the Republic.
Livas, are you following?
Yes. I do have a copy of Annex 2. So but I can't share the screen now. I can't share the screen because I don't have the right.
Chair, Mr. Mabaso has been given the rights right now to share the screen if he wants to go ahead.
Livas.
Okay, let me see. More. Okay, share screen.
Livas.
Chairperson, I think if I may, Chairperson.
We are of different age and different background. Let's not
Is my screen visible now, Honorable Chair?
Your face is very visible. Yeah. Yeah, no. Technology is not a game of all of us. Can we accept that you'll not be able to share your screen, at least for now? Or you want to try again? If you can't, we won't really get angry with you. We understand. There you are. Wow. Long live. Long live. Yeah.
So, but then the reference to appropriate authority, Honorable Chair, so that you understand the context.
Yeah.
When it comes to air marshalling, because others will leave it to the entity responsible for aviation security regulation in that state. And then others, it will be the responsibility of the National Army. And then others may use another organization. They may delegate that to another organization to control the airspace in terms of security. So it's different setups with regard to different countries. That's why then we don't want to mention any particular entity, because then that might not be the entity responsible in a state. So that's why we say appropriate authority.
Honorable Ansinger.
Chairman, the definitions where we are now might help us, because there is a specific definition which gives us insight into that. If we could just read that. Thank you, Chair.
Leave us.
Well, appropriate authority, A, regarding flight over the high seas, the relevant authority of the state of registry. B, regarding the flight other than over the high seas, the relevant authority of the state having sovereignty over the territory being overflown.
Thank you, Chairperson. It's quite clear. Also, thank you, Mr. Mabaso. We are impressed. Thank you, Chair.
Thank you very much, honorable members. Any support?
Support amendment. Thank you, Chair.
Thank you very much, Honorable McD. Advocate Almanel, let's forge ahead.
Thank you, Chair. Then we move to clause 51. 51 has quite a few consequential amendments to section 133. Just to flag 133 for members here. 133 deals with offenses and penalties on board aircraft, and then here's all the other ones as well. So, Chair, this one is amendments in F, G, H, and I, where there is reference to airport, heliport. The proposal is to substitute those for the use of aerodrome. We see aerodrome here again, all the way through to I as a consequential amendment. Chair, then in paragraph J, we see the same. And then in the proposed amendment here, it's to add subsection 2, a person commits an offense if that person, and then it's this entire list here, all the way from A down, Chair, subsection 3, subsection 4, and then up to a minimum period of 20 years without the option of a fine. So that is the proposed amendment here to section 133. So we'll change FGHI, and we will change J2, and then underneath J we get the new additions, which is the new subsection 2 and 3, Chairperson. So that is quite an extensive list there for members to consider for approval, or if they need some clarity, as per the previous discussions, whether or not it will be sufficient to use aerodrome and to substitute airport and a heliport here, Chair.
Thank you very much, Advocate Nell, for coming back to me. We have discussed this issue of drones and helipads, airports, and so forth. Leave us. Is your hand up?
Thanks, Honorable Chair. In fact, I raised my hand on the previous section. It's just a technical issue. We don't necessarily have to go back to it. The International Civil Aviation Organization is a name of an organization given by the convention, and it's spelled with a Z. So I see in that it has been spelled with an S, so it becomes wrong. So it should be spelled with a Z. The organization should be spelled with a Z, as it's a name of an organization.
Okay, Livers. I can hear you are from Limpopo in South Africa. Am I correct?
Yes, Honorable Chair.
Yeah. I'll tell you one day how do I get to understand the people of Limpopo when they called organization. I know this one is for Limpopo. Honorable Manu.
Chair, we can prove that Livers is awake. He's not sleeping. Chair, I do support these recommendations, significant as they are, but I went through them. And I think the issue of the aerodrome, as you say, we went through it, and it does cover everything else that is being deleted. So I am in support of the proposed amendments. Thank you, Chair.
Thank you, Honorable Member Manu. Honorable Chris Hansinger, thank you for supporting. Advocate Almanel, let's forge ahead.
Chair, in our A list, we will also correct this spelling error here at C, where it should be by the addition. So that is already in the draft A list that members have before them. So I just wanted to point that out. Then, Chair, the issue that Levers highlighted, our legal team already has it on the cards for the new A list. So we will be sending the new A list out to members as soon as we've added the most recent ones. Then section clause 52 will amend
Chair.
section 140.
Chair, if I may, Chair.
Yes, Honorable.
Apologies, Chair. I got sidetracked by the sleeping or not sleeping of Livers. I wanted to check with the department. It's not anywhere proposed, but it has just come to my mind where I observed somebody who was arguing the air hostess about putting on a mask or not putting it on properly. And the question is, just for clarity, given what we find ourselves in terms of offenses, in terms of this act, I know interfering with a cabin crew member is an offense. Where is the issue of COVID directions, stroke, regulations taken care of when it comes to civil aviation matters? Chair, I just thought I'll raise it because we are dealing with offenses here. And if I'm out of order, you are more than welcome to kick me to touch. Thank you, Chair.
Okay. Yeah, that's an interesting one. Advocate Masombu.
COVID.
Chairperson, the issue of directions for disaster purposes are issued in terms of the Disaster Management Act. And we issue the civil aviation directions or the seaport directions or the roads or public transport directions through that particular Disaster Management Act. Thanks.
Thank you very much. Thank you very much. Advocate Babulisa Wagamangu.
Yes, no, Chair, thank you, Chair. Advocate likes writing SMSs, you know. I appreciate it. But explain to somebody who's not a lawyer. When I'm in a plane, I hear every announcement talks about port health regulation or authority and civil aviation. It would appear to me that the cabin from captain, whoever, derive their authority from the Civil Aviation Act more than any other act, unless they are not aware. But however, Chair, maybe it's something we can discuss some other time. I just thought, because we are dealing with this act and we find ourselves in these situations, which we don't know in the future what will happen. But maybe because it's not here, let me not delay the meeting, but I advocate made it very too simple and too short, but maybe we can move on, Chair.
Thank you, Honorable Manu. Advocate Al-Manel, let's conclude with clause 52, please.
Chair, I think just to assist our member, when we do get the Disaster Management Act regulations, there's also amendments that are gazetted along with those specific to air travel. And that is those ones that will then link up with the specific COVID compliance issues that are required for that specific level. So when you get on the aircraft, you will have to comply with those amendments in the regulation, Chair. So it's all encompassing. You have to comply with all South African legislation as well as those ones. Then section clause 52 will amend section 140.
Chairperson, before we step off there, Chairperson, my hand was up.
No, it was not up. Request me nicely. Don't patronize me. What do you want to say, Honorable McDonald?
Chairperson, I just wanted to refer back to that. Chairperson, honestly, my hand was up and then I put it down again and then I put my hand up again. But thank you very much, Chairperson, for indulging me. Apologies, Chairperson. On that subsection 3, is a conviction liable to imprisonment for a minimum period of 20 years without the option of a fine? Does that include for not abiding to an instruction from an air hostess that you would go to jail for 20 years without the option of a fine, Chairperson? I just wanted to get clarity on that, Chairperson. Our apologies, Chair.
Thank you very much. If you disobey, you go into jail. But let's hear. Advocate Masombuga.
Thanks, Chairperson. The answer, you get it under 4 there, which says any person who commits any offense in subsection 2. Therefore, you must read subsection 2 offenses. And 3 is on conviction liable to an imprisonment for a minimum period of 20 years without an option of a fine. So those that are mentioned in subsection 2 and 3, this will be the fine that you'll be liable to. Thanks.
McD, are you clarified?
Chairperson, I'm not 100%. I don't see the part. Can I just, if Advocate Nel can just go to the point there. Okay, Chairperson, I'm clarified with that subsection. Thank you, Chairperson. Thank you.
Is your hand lowered now, McD? Thank you. Thank you very much. Advocate.
Thank you, Chair. Clause 52 amends section 140. 140 deals with the prohibition and control in restricted areas. So, Chair, there'll be an addition here under sub A, an authorized person, officer, or inspector. So just used to be an authorized person. And then subsection 2 will be an authorized person, authorized officer, or inspector. So those words are added. And then, Chair, in subsection 3, it's the same as 2. We're adding here authorized officer or inspector. And then we're changing airport reference to aerodrome. Chair, and then it's up to there we have the amendment to 140, section 140. 140 is quite large, Chair. But that is the main amendments there, is adding officer or inspector and the change from airport to aerodrome, Chair.
Thank you very much, Advocate. Let me see happiness from the side of the members.
Supported, Chair.
Thank you very much, Chambase. Any seconder?
Seconded, Chair.
And Thank you, and Honorable Pete May also. Thank you very much, honorable members. Unfortunately, our time has come to the point where we have to end at clause 52. We have given it our best shot. I hope everybody will see that. We will continue with the issues of civil aviation on Friday, not tomorrow. At this point in time, I wish to give members 3-4 minutes to stretch their legs while Advocate Almanel is preparing her documents for ERT bill that will be deliberating on shortly. Leave us. You want to leave us?
Yes, with your permission, Honorable.
No,
Good night. Good night, Liver. Good night.
No. No, I had not requested Honorable Mangu to say it, but it is appropriate that we should say good night, my brother. To have your rest. We know you are a busy man. We shall see you when you see us, maybe on Friday.
Thank you, Honorable Chair.
Thank you very much. Mkhayeso, o fihlile le wena jwale mona ke a tseba o fihla o tla tla ka morusu.
No, Chair, I wanted to compliment your sense of humor. As a former teacher, I take it that that's where you got it from.
Hey man, there's something what like.
Thank you, Chair.
No, it's a really breaking at 3 minutes. It's a monaco yeah. Okay, I'll have a compliment.